Hello and welcome to OSLR's webinar series, Brief the Board. I'm Eric Morgan. I'm an associate in OSLR's litigation department in Toronto. This is a series of webinars that OSLR is presenting on how Council can brief their board members and senior management about a variety of litigation topics. In today's webinar, we'll be discussing briefing boards and senior management about hot topics in employment law, in particular, employment issues for franchises and random drug and alcohol testing. If you have any questions during the webinar, please email us or type them into the area provided on your screen, and we'll respond to them as time permits. I'm joined today by Jennifer Dolman and Brian Teason. Jennifer is a litigation partner here at OSLR in Toronto. She has a broad commercial litigation practice with an emphasis on assisting Canadian and international franchisors with their business-critical disputes. And with that, I'm going to turn it over to Jennifer.
Thanks, Eric. I'm going to talk about labor and employment issues in franchising. Good place to start is to review what is a franchise. A franchise relationship, importantly, is distinct from an employment relationship. A franchise is broadly defined under franchise legislation, like Ontario's Arthur Wishart Act Franchise Disclosure 2000. I'll call that the AWA. There are actually 5 other provinces in Canada with franchise legislation like the AWA, but for today's purposes, I'm just focusing on the AWA. Under the AWA, there are 3 key elements of a franchise. The first is payment to the franchisor in the course of operating a business or as a condition of acquiring the franchise or commencing operations. The second is the franchisee being granted the right to sell, offer for sale, or the right to distribute goods or services substantially associated with the franchisor's or franchise associate's trademark, service mark, trade name, and the like. And thirdly, the franchisor must exercise significant control over or offer significant assistance in the franchisee's method of operation. The AWA expressly states that it does not apply to employment relationships. In 2015, the Changing Workplaces Review was initiated in Ontario by the Ministry of Labour to consider issues affecting the workplace. 2 special advisors were tasked with making recommendations to the government to address the changing nature of the workforce, the workplace, and the economy. They were focused on 2 Ontario statutes, the Labour Relations Act and the Employment Standards Act. Public consultations were held in 12 cities across Ontario in 2015. In July 2016, an interim report and guide were issued. Approximately 50 issues were addressed and over 225 options raised for further consultation. One recommendation was that franchisors be deemed joint employers with their franchisees of their franchisees' employees. Prior to this particular proposed amendment, the question of whether a franchisor was a joint employer with its franchisee of its franchisees' employees was decided on a case-by-case basis with varied results and depended on that franchisor's control of its franchise's day-to-day operations. The idea that franchisors could be deemed to be joint employers by legislation was considered a significant threat to both the franchise model, but also to Ontario's thriving franchise industry. Joint employer status, if across the board, could expose franchisors to employees' claims under employment and labor laws, collective agreements, wrongful dismissal suits, wage and overtime class actions, and human rights claims. So again, even though prior to this proposed amendment, there had been findings of joint employment status, that was on a case-by-case basis. It wasn't just deemed by legislation as being necessarily so. What are the direct and indirect impacts of joint employer on a franchisor's business? Well, those could include increased liability in respect of the franchisee's commitments to their employees, including liability for wages, salaries, overtime, vacation pay and benefits, termination notice and pay in lieu of notice, severance pay and employment-related premiums, payroll taxes, really any situation in which monies are owed to employees. If a franchisor was deemed to be a joint employer, then they would be responsible together with the franchisee for any outstanding monies owed to employees. And as a result, because of this potential liability, there would be increased costs on the part of a franchisor to ensure that the business was compliant with statutory labor and employment obligations. And because the typical franchise model has the franchisor passing certain costs through to the franchisee, there would need to be changes to the economics and incentives in a franchisor's business model as it tried to flow these increased costs and operational burdens through to its franchisees. And then franchisees who typically have a autonomous existence from their franchisors, they operate independent businesses, but under the license from their franchisors, they would experience a loss of autonomy over the operation of their businesses if the franchisors were going to increasingly become more involved because of the increased exposure to liability. And then there was an increased risk as well that franchisees' employees could become more unionized. The final report was released by the special advisors on May 23, 2017. And a great result for not just franchisors, but franchisees as well, because they would be impacted by franchisors being deemed to be joint employers with them. The final report specifically rejected this adoption of a proposed new deemed joint employer status for franchisors. So this was a very exciting and welcome news for the entire franchise industry, but notwithstanding that there will not be legislation deeming franchisors to be joint employers with their franchisees in Ontario, franchisors do continue to remain at risk of being found to be a joint employer. And because there was so much publicity around this issue, both the Canadian Franchise Association and the Ontario Bar Association franchise law section were advocating against this particular proposal. A lot of franchisors themselves were meeting with the special advisors to advocate against these changes, and there was a lot of newspaper write-ups and the like. So it was very much a hot topic, such that I think franchisors should still be expecting this issue to be on everybody's radar. And if there's a particular dispute between an employee and a franchisee, the employee's counsel may very well decide to name the franchisor in any complaint or suit, particularly because franchisors typically have deeper pockets than their franchisees. As such, it is very important still for franchisors to take steps to try to avoid a finding of joint employer status. And franchisors therefore need to think carefully about the extent to which they control the day-to-day operations of their franchisees. Franchisors must afford franchisees a significant level of independence and discretion when it comes to employee hiring and firing, scheduling, wages, personnel files. And yet franchisors at the same time, because they're the ones who own the trademarks and they're the ones who have created the system that they franchised, and they're the ones with the know-how and the skill set and the brand and reputation, they do have to, of course, take steps to make sure that their brand is sufficiently controlled. So there needs to be a careful balance between taking steps to ensure that the franchisor's own trademark is preserved and its reputation and that system standards are complied with, but at the same time not get too deep in the weeds in terms of the franchisee's relationship with its employees. So franchisors need to step back and let their franchisees deal with hiring and firing and scheduling and everything that is more closely connected to the actual employment relationship between its franchisees and its franchisees' employees. And so franchisors should focus on practices that impact the consumer's experience with the brand, but steer away again from steps that they would take that are too closely involved with what the franchisee needs to mandate of its employees. One thing franchisors should consider doing is taking a close look at their franchise agreement and their operations manual to see what provisions are in there that may be too close to employment practices, and they should eliminate provisions that go too far, or they at least should take steps by consulting with franchise counsel as to what is necessary to protect their brand, but not to get too close to the franchisee's relationship with its employees. Franchisors should make sure that it's the franchisee's name and not the franchisor's that appears on store-level receipts, stationery, employment applications, pay stubs, accounts, websites, etc. The employees, but also consumers, should understand that the franchisee is an independently owned and operated business under a franchise agreement with a franchisor, but that the franchisee is not the same as the franchisor. The franchisee is a separate company from the franchisor and operates independently from the franchisor, although with the license of the franchisor to use the franchisor's system, marks, etc. Although the final report did not recommend, as I've discussed, that franchisors be deemed joint employers, it did recommend a process that could create a more direct route to unionization and allow employees of multiple franchisees operating the same brand at multiple locations the opportunity to bargain collectively. So again, great news was not having the deemed joint employer status in the report as one of its recommendations, but still a recommendation that could lead to a more direct route to unionization. The final report was accompanied by a statement from the Ontario Minister of Labour that the government would announce its response to that report within a week. So a very quick result from that. And indeed, on June the 1st, 2017, the Ontario government released Bill 148, the Fair Workplaces, Better Jobs Act 2017. The second reading was dispensed with, and the bill has been referred to a standing committee to consider over the summer. And Bill 148 is intended to implement certain recommendations from the final report. Fortunately for franchisors, Bill 148 doesn't propose that multiple franchisees of the same brand operating in the same geographic area be required to bargain together with local employees towards one collective bargaining unit. That had been one of the recommendations in the final report. Another recommendation that did not find its way into Bill 148, notwithstanding the final report recommendation, was that an employer bargaining agency made up of representatives of the franchisee employers represent the franchisees at the bargaining table with the union. There are proposed changes to the Labor Relations Act, however, that may increase the number of union drives and successful applications for certification. Again, these are just proposals. The legislation has not been passed and is not in effect yet. But the amendments would allow Ontario Labour Relations Board, the OLRB, to change the structure of bargaining units within a single employer. And this would make it easier for employees of a single employer operating multiple businesses to be certified as one business unit. And this could impact not just franchisors that have multiple corporate stores, but it could impact multi-unit franchisees who have more than one location in close geographic proximity to each other. And this would be open to trade units in building services, home care and community services, and temporary help agency industries to apply for certification without a representation vote. And importantly, building services industry is broadly defined, and that includes a whole bunch of services, segments of the economy that are commonly serviced by franchise brands, such as cleaning services, food services, and security services. The OLRB would have the discretion to certify the union if satisfied that more than 55% of employees in the bargaining unit are members of a trade union. And the OLRB would also have discretion to dismiss applications for certification without a representation vote, where it finds upon application of what is being referred to as an interested person that there's evidence that the application does not likely reflect the true wishes of the employees. Where no trade union has been certified as a bargaining unit and no collective agreement in place, a trade union may apply to the OLRB for an order for an employer to provide a list of its employees. And if that were to happen, a trade union, if successful, could use the list in its campaign to establish bargaining rights. So that's on the unionization side, which can be quite technical, but all the provisions are available online looking at the proposed bill. Significantly, there are other proposed changes to Ontario's labor employment law regime that will impact not just franchisors and franchisees, but all small businesses. And I can't get into all of these, but these are topical right now, and franchisors are considering the impact of this on the industry, but so are franchisees, because they're the ones who are impacted directly in terms of requirements around employment. So it affects franchisors because if this is passed, it impacts the burden on the franchisees, and that in turn may concern people entering into franchise agreements and impact the industry broadly. So the types of proposed changes that have been included in the bill are new shift scheduling rules with a target effective date of January 1, 2019. And so there's a lot in that particular topic in terms of employees' rights to be able to get paid in the event of not getting very much notice about shift changes and the like. Equal pay for equal part-time work provisions, giving rights to casual, part-time, temporary, and seasonal employees. And then the one for which there's been a particular amount of press is the proposed increased minimum wage that would find Ontario's minimum wage increase to $14 an hour by January 1, 2018, and then $15 an hour by January 1, 2019. So if this is passed, obviously franchisees have to comply with this law and will have to pay these increased amounts, but that doesn't just impact those employees of franchisees who were getting minimum wage. It impacts all employees, because there's a certain class of employees who, although being paid more than minimum wage, would be entitled to just perhaps a bit more than minimum wage. And so when minimum wage goes up, then the wages of all the other employees would be expected to go up as well. And so again, that is going to increase the overall costs. So in summary, the great news is no deemed joint employer status in Ontario, although franchisors need to be mindful. But we have to wait and see what gets passed in this legislation around unionization and particular changes that will impact the businesses that franchisees operate in terms of what the employees' rights are and their entitlement to wages.
Thanks very much, Jennifer. We're now joined by Brian Teason. Brian is an employment law partner at Osler's in Calgary, and his practice focuses on the managerial side of employment and labor issues. And I'll turn it over to Brian.
First of all, as an agenda, we're going to cover an overview of drug and alcohol testing in Canada, focusing on the Irving decision out of the Supreme Court of Canada. Then we're going to talk about post-Irving case law and arbitral decisions out of labor and arbitration boards. And thirdly, we'll talk about some practical suggestions as employers engage in drug and alcohol testing. So as an overview, we'll start with an overview of drug and alcohol testing. First of all, employers have a statutory obligation to provide a safe workplace and accordingly have a legitimate interest in doing so. This arises out of the occupational health and safety legislation in each jurisdiction, which provides a statutory duty to maintain a safe workplace. There's no legislative regime in Canada that specifically governs drug and alcohol testing in the workplace. So all of the case law is out of common law decisions and particularly labor arbitral jurisprudence. The balance that's struck in drug and alcohol testing is always between an employer's legitimate interest and obligation to provide a safe work environment on the one hand, and on the other hand, the employee's privacy and human rights. So it's really a weighing, balancing of those interests. So the key decision of any review of drug and alcohol testing in the workplace is the Communications, Energy, and Paper Workers Union of Canada, Local 30, the Irving Pulp and Paper, which is really just the Irving decision of the Supreme Court of Canada. Irving involved a case with random alcohol testing. It was an employee who was working in a pulp mill in eastern Canada and was subject to random alcohol testing in the workplace. And the Supreme Court of Canada said that an employer must establish that its workplace is, number one, dangerous, and number two, an employer must provide evidence of enhanced safety risks, such as evidence of a general problem with substance abuse in the workplace. So looking at those requirements, drug or alcohol random testing in the workplace, the starting point is always, is it a dangerous workplace? Is it a safety-sensitive work environment? If you don't pass that part of the test, if you're an office worker, management that doesn't work in the field, not permissible. So first of all, safety-sensitive, but that only gets you past the first part of the test. The second piece, you need to demonstrate this enhanced safety risk, such as evidence of a general problem with substance abuse. Irving provides little guidance with respect to the degree of seriousness of drug and alcohol problem in the workplace that is required to justify random testing. In the Irving decision, there were only 8 undocumented incidents of alcohol consumption or impairment in the workplace over a period of 15 years. We know that the Supreme Court of Canada held that to be insufficient, but we'll look at other case law to talk to a little bit about what might be sufficient to demonstrate evidence of enhanced safety risk. The deterrence value of random testing was not really given real consideration in Irving, although it has been raised in subsequent decisions. So we turn to an overview chart on slide 6 of the presentation, looking at the testing methods and permissibility. And if we just run through the types of drug and alcohol testing, you can see that the first type of testing is called, pre-employment testing. That type of testing is possibly permissible. If we look at pre-employment testing, such as in the Teason decision out of the Alberta Court of Appeal, pre-employment drug testing in that context, the courts have said, if you demonstrate an issue with addiction, the employee must be given a chance to reapply, enroll in a treatment program, and reapply. Then possibly pre-employment testing is permissible. Universal random testing. That term is coined in the Irving decision. And in the summary of the case law here is possibly, you can possibly engage in universal random testing in a dangerous workplace with enhanced safety risks, such as demonstrated problems with drug and alcohol abuse. the Supreme Court of Canada in Irving went so far as to say that the safety risk would have to outweigh the unassailable conclusion of the significant inroads that random testing would have on employee privacy. So you see the test that we're up against. Reasonable cause post-incident. So reasonable cause testing, where you have reasonable suspicion that an employee is subject to the influence of substances, or where there's a serious post-incident incident in the workplace of motor vehicle accident, for example. Case law is clear that you can engage in testing in that circumstance. Post-reinstatement testing is permissible, has been permissible for some time, if it's a broader facet, if it's a necessary facet of a broader assessment process for a stipulated term only, most commonly 2 years. So that's often a employee who suffers from an alcohol or drug addiction issue, engages in a treatment protocol, and then has post-reinstatement testing on a regular basis, even random testing. Mandatory disclosure of a current problem is you as an employer are entitled to require, and mandatory disclosure of a past problem for 5 to 6 periods after successful remission for alcohol, 6 years period for drugs is what Irving stipulates. So after Irving, the decision of the Supreme Court of Canada, we take a look at some of the arbitral decisions that the labor boards have taken a look at for the Irving standards of random drug and alcohol testing. So in Suncor Energy Inc., the Unifor, which involved random drug testing, the arbitrator in that case permitted a grievance by the employer, by the union, and found that Suncor failed to establish evidence of a problem with alcohol and drugs in its workplace amongst its unionized employees. The testing policy was found to be too broad, did not use the least intrusive or most accurate testing measure, and did not contain provisions for communicating with employees regarding false positive results. In Tech Coal, that was a grievance that sought to strike down Tech's random drug and alcohol testing. The employer established significant risks of industrial accidents in its workplace. Although no history of accidents caused by impairment, the grievance was struck as safety outweighed the employee's privacy concerns. In Tech Coal and UMA before the Alberta Labour Relations Board, the Alberta Labour Relations Board went the other way. In a similar grievance, the arbitrator found there was no enhanced safety risk, consistent positive tests, or link between workplace incidents and drug or alcohol use. And then finally, recently in the TTC decision, the judge dismissed an application for an injunction against the TTC's random drug and alcohol testing policy, citing the deterrence effect of the policy and its ability to increase public safety as reasons for the judge's decision. Keep in mind, like some of the previous decisions we've discussed, these are initial applications for injunctions to bar application of the drug and alcohol testing policy. 11,000 random tests carried out between October 2010 and December 2016 found 291 documented cases of questionable behavior, and there were 45 instances of employees buying or selling drugs or alcohol on the job. So the court in those circumstances said that the case can, of course, proceed to arbitration. The court declined to impose an injunction prohibiting drug and alcohol testing in the circumstance, and allowed and pointed out that if there was serious violations of privacy, for example, that tortious claims provide adequate compensation, and there was no need for an injunction to stop the testing in the meantime. So practical suggestions arising out of Irving as well as the arbitration decisions. Having a drug and alcohol policy and protocols and procedures in place, really at this day and age, you cannot proceed with drug and alcohol testing of any form without proper protocols and procedures in place. Having a strong occupational health and safety policy and protocols in place, if you're going to justify drug and alcohol testing on the basis of a safety-sensitive work environment, and particularly a safety-sensitive job position, you cannot do so without having a proper occupational health and safety policy and protocol. Training frontline managers and supervisors on policies and protocols every 1 to 2 years. I think particularly with the amount that the case law evolves and the arbitration decisions are evolving every day, providing up to speed, up-to-date training for those managers and supervisors is essential. Keeping records of workplace safety incidents. As you can see from the background decisions, labor and arbitration decisions, one of the key factors is establishing a significant risk of industrial accidents in the workplace. It's almost impossible to do if you do not keep a accurate, proper record of all workplace safety incidents. That includes for workplaces, even on post-reinstatement testing, which is not controversial, but having an idea of what that post-reinstatement after a time off for drug addiction, et cetera, what type of numbers an employer experiences in that environment can be very important for trying to institute, for example, universal random testing at a subsequent date. Keeping records of drug and alcohol incidents, employees, whether safety or operationally related or not. Really, any kind of records of drug and alcohol incidents, finding drug paraphernalia on the work site. If an employer utilizes sniffer dogs and they detect a positive walking by lockers, every incident, whether or not part of the operations, needs to be recorded. Complement drug and alcohol testing regime with management observation. This is just as important as testing. So, what manager and supervisors can look for is slurred speech, unsteadiness, red eyes, etc. That's a big part of reasonable cause testing, for example. It forms a basis for whether an employer has reasonable cause to drug and alcohol test an employee in a specific circumstances. Decision makers will be more likely to uphold drug and alcohol testing policies that are tailored to address legitimate workplace safety hazards, which can be demonstrated with concrete evidence of workplace drug and alcohol problems. So really, all of the previous points are, if you're going to, if you believe at some point you are going to get to a decision point on implementing universal random testing, for example, that is a multi-year project where you gather evidence over years. You have a good idea of your workplace picture, the amount of safety-sensitive events that you have before you even make the decision to engage in universal testing. And then if you do so, you will want to have that evidence in place before you institute such testing. An employer that wants to implement random drug and alcohol testing will need to lead evidence of general workplace problem with drugs or alcohol, as well as evidence of the inherent dangers in its workplace if such problem is not addressed. So looking at the TTC decision, for example, which was an injunction decision, you can see the type of information that the court is looking for. 291 documented cases of questionable behavior, 45 instances of employees buying or selling drugs or alcohol on the job. So that was a 6-year period of measurement with multiple incidents, details on exactly what's going on, that drugs and alcohol are being sold in the workplace and how many times. That's the type of evidence you're going to be looking for in order to establish a bona fide drug and alcohol testing or a universal random testing program in the future. So those are the practical suggestions. Thank you very much. My name is Brian Teason. I'm the partner in the Employment and Labor and Privacy and Data Management groups at Osler. Thank you for your time, and I appreciate your listening in today.
On behalf of Jennifer and Brian, thank you very much for joining us for this webinar. We hope it's given you some useful insights into these emerging areas of employment law. You can find more information and commentary on risk management on Osler's risk management blog at riskandcrisismanagement, all one word, .com, or at osler.com under the resources tab. Thank you again for attending this webinar, and have a good day.